We're going to go into the panel discussion on privacy and security in the age of NSA and Snowden. I'm Edmund Moe-Martin. I'm Board of Directors of ISSA Los Angeles. And thank you very much for sharing your day with us. This is the last segment before the ending keynote. So I'm going to do a brief introduction for the panels. Alex Abdo, a staff attorney in the ACLU's Speech, Privacy, and Technology Project. He's a counsel in the ACLU's challenges to the lawfulness of secrecy surrounding various NSA surveillance programs, including ACLU versus Clapper and ACLU versus NSA. Nate Cardozo, staff attorney on the Electronic Frontier Foundation's Digital Civil Liberties team, focuses on free speech and privacy litigation and EFF's annual Who Has Your Back report. Dr. Stan Stahl, president of Citadel Information Group. He's also president of Los Angeles chapter of ISSA and the architect of chapters It Takes a Village to Secure the Village program. Monica Ryan, chief of the Privacy and Civil Liberties Unit in the FBI's Office of General Counsel, and she currently serves as the Privacy and Civil Liberties Officer of the FBI. And finally, Stewart Baker is a partner in the law firm of Steptoe and Johnson, Washington, D.C. From 2005 to 2009, he was the first Assistant Secretary for Policy and Department of Homeland Security. And he has also been the General Counsel of the National Security Agency. And finally, Richard Greenberg, CISO of Los Angeles County Department of Public Health. He's also a ISSA fellow and president of the ISSA OWASP Los Angeles chapter. So,
thank you, Edmund. Appreciate it. Thanks for coming, everybody. As you can see, we've tried to cover all the different positions. Can you hear me okay? I think I'll set this one down. I'm mic'd. We try to cover all the philosophical perspectives on this really key issue. We have representation from FBI, former DHS official, ACLU, EFF, and then our own Stan Stahl, who we've looked up to for years. So we have some questions. We're going to ask them. And at the conclusion, we'd like to invite you both. There's mics up there. Line up. And we're going to leave about 10 minutes, which should be an ample amount of time for those of you who want to ask questions of our panel. Before we begin, humor me. And I know many of you probably look at this slide and go, well, I'm not sure. Maybe yes, maybe no. Choose a side just for the sake of a vote. I just want to see a show of hands. Snowden, good. Okay. Next, Snowden, bad. Okay. Curious. We're going to take another vote at the end. I'd like to see what happens. Yeah, it's about 61% to 39%. All right. The U.S. government and corporate actions. Snowden's actions have led to a reinvigorated interest in government oversight. Privacy advocates, however, are concerned about both corporate data collection and government spying. So here's the first question for our panel. Transparency in intelligence is clearly good for democratic accountability and bad for actually collecting intelligence. How much transparency about our intelligence methods should we demand? Monica, would you care to kick things off?
Can everyone hear me? Okay, good. Is that on? Good. Well, I think that's an important policy question for the American public. You know, we need to ask ourselves through our elected representatives, what do we want our government to do for us? And I would suggest that one of the things to think about when trying to answer those kinds of questions is to think about the relationship between transparency and trust in what the government is doing. Questions that we might want to ask are, do we trust the members of the intelligence community and the government at large to follow the rules that are set for them? And do we trust the oversight framework to come up with the right rules for those people to follow? I'd suggest to you that, as you may have learned since Mr. Snowden did what he did, that there's a very, very extensive oversight framework, legal framework that the members of the intelligence community are mandated to follow. And I think to date, there hasn't been much to say that those rules have not been followed. I think the question for the American public now is, are those rules sufficient? Do those address the needs and concerns that you have? I think the government can do a better job at explaining how we're doing what we're doing, even if we can't talk about exactly what we're doing, because for intelligence to work, you have to be able to keep secrets, right? That's part of the business. But explaining in a more publicly accessible way what rules we have to follow, what sort of standards we're held to, what kind of oversight and reporting and what kind of accountability there is, I think is something that we are learning from this process that we can do better and probably should do better. I know that I can point to that there has been an effort. There were things that were available to the public before Mr. Snowden leaked the information that he did, but there has since then been, I think, a renewed effort on the part of the government through people like in the positions that I have and people who have been talking to the various oversight authorities in Congress and in the FISA court and the IG, all kinds of places. Everybody's understanding that there's a real need to be more transparent about what the rules are, why we follow them, and what we're doing to make sure that we follow them right. So there's the IC on the record on Tumblr. There are different kinds of public-facing documents on many of the agency's websites, including the FBI. We have privacy impact assessments that are available to the public, and we've had those for years. We have published our system of record notices in the Federal Register. Many portions of our domestic investigative guidelines, so we call it our DIOG, that's available on our website for people to see. And I will just note for this group that the Privacy and Civil Liberties chapter is completely unclassified, always has been, and has always been publicly available. So I encourage you to go look at it and see what it is that the FBI is required to do. Every employee is trained to that manual and is expected to follow those guidelines.
If I could respond to just one thing that Monica said, in that, yes, there is a supposedly robust oversight structure set up to monitor the intelligence community and make sure that it follows its own rules. And as Monica pointed out, the cornerstone of that oversight is the Foreign Intelligence Surveillance Court, the FISA court. In 2011, the FISA court, and these are its own words, said that that system had been so frequently and systematically violated, so it could be said to have never functioned effectively in the first place. And that's Judge Bates writing in October of 2011. In a perfect world, Monica's absolutely correct. We don't live in a perfect world, and it's really time to make sure that the oversight bodies that are in place are functioning correctly. They have not been to date. So that's my perspective on the issue.
Let me take a step back and talk a little bit about transparency. It's very tempting, because this is how our system works, to think that the more the American people know about what we're doing in their name, the better the oversight will be, and that is certainly true. But unfortunately, the more the American people know about what is being done in the intelligence community, the more Al-Qaeda and Vladimir Putin know about what is being done by the intelligence community. So you can have transparent intelligence, you just won't gather any intelligence when you do that. So there's a genuine struggle over this. We simply cannot do what we usually do, which is count on the newspapers to tell us the things that we need to oversee. And everybody who has followed the intelligence community reforms over the last 40 years has understood that and has tried to build an oversight system that can function without exposing the sources and methods that the intelligence community uses. And in an effort to do that, they have built a classified system of oversight that is far more aggressive than any other country in the world, that has involved oversight by Congress with cleared staff and cleared members, clear judges, and obviously a host of executive branch oversight officials who have reviewed many of these programs. What I think is, in the end, we don't have a choice. If we want to have intelligence, we're going to have to use that system. We cannot just say, well, occasionally it'll leak and then we'll have oversight, because then you will lose your intelligence capabilities. What I think is particularly hostile to this whole system that we constructed is the counter-narrative that Edward Snowden has put forward, which is that the oversight wasn't working and I had to leak this to start a debate. He did not leak his information, even about the 215 program, the metadata program gathered by NSA, to start a debate. He claims that he was watching when Clapper made the statement about the program that he later characterized as the least untruthful thing he could say, but basically saying we don't wittingly gather information on masses of Americans. And Snowden said, that's the moment I decided I had to go public. Well, if he was watching what Clapper and Wyden were saying, he must have known that Wyden had been saying this for 2 years. For 2 years, Wyden had been delivering a coded message to everybody who understood this program that said the American people would be upset with the legal interpretations that are being adopted under the Patriot Act. They would not believe that the words that are being approved are being used to support programs that are as intrusive as they are. You can't, if you understand this program, you know he's talking about this program. He talked about it for 2 years. Snowden knew that too, because Snowden understood this program. What he then realized, he must have realized, is oversight wasn't failing. There was a debate inside the U.S. Congress, a debate between members of the Intelligence Committee about this program and whether it should be permitted to continue. And that was a debate that was going on between the executive branch and Congress. It was not necessary to leak the program to have a debate. It was necessary to leak the program to win the debate. And he leaked this program in a fashion designed to shock people by leaking the fact of the collection 2 weeks before he allowed the leaking of all of the limitations that had been put on the program. 2 weeks in which this entire narrative was settled by the shock that people felt by seeing the program without understanding what the limitations were. What Snowden did was fundamentally inconsistent with our democratic process of allowing oversight by the people that we elected. We didn't elect him. We elected Ron Wyden and the rest of the members of the committee. And what Snowden did, even though he dresses it up as trying to provide oversight, was designed to defeat the oversight system that we put in place.
So maybe I'll continue our government-private bounce back and forth. I don't disagree with much of what Stewart said until he started talking about Edward Snowden. I think what I disagree with what he said is how you effectuate this line between intelligence gathering secrecy and adequate democratic oversight. And I think one of the primary lessons that we learned from Edward Snowden's leaks is that there are certain questions that are simply too important in a democracy to leave to the sort of secret oversight that Stewart is talking about. Now, in the 1970s, the intelligence agencies came to essentially a grand compromise in which they agreed to certain oversight of their practices following the revelations of the Church Committee. And they said, we'll agree to that oversight, but the oversight will be secret. And that worked by and large until 2001, when all of a sudden what the government was doing was not targeted surveillance, but had shifted from targeted surveillance to dragnet or bulk surveillance. That's the sort of shift that has to be debated openly in a democracy. It's not the sort of shift that you can leave to the sorts of secret determinations that Stewart is talking about. And I think one way you know that is by the reaction to the exposure of the phone records program. In secret, the program was approved by every judge who had listened to a one-sided argument by the government. In secret, every congressman who knew about the program, which was not all of them, but everyone who knew about it had approved the program. And in secret, 2 presidents from different administrations approved of this program. Once it became public, the public's reaction was dramatically at odds with the secret determinations made by the political branches. And that's not surprising in a democracy. Those sorts of questions, I think, have to be debated publicly in order for there to be legitimacy in intelligence gathering, in order for there to be trust by the American public in what their intelligence agencies are doing on their behalf, and in order for these democratic processes to work properly. You know, just to say a word about Edward Snowden. So I think I disagree with Stewart's characterization of what his purpose may have been, but I think there's really two fundamental things that we've learned from his revelations. The first is what I said before, which is that he revealed a broken system of oversight, a system of oversight that had fundamentally failed to address the problem that it was designed to address, and it had allowed for questions that should be addressed by the public to be addressed in secret. And the second thing I think he revealed is that we now live in a world in which truly pervasive surveillance is possible. We don't live in the world of the 70s, the 80s, and the 90s in which the NSA was operating primarily pursuant to individualized court orders from the Foreign Intelligence Surveillance Court. We live in a world in which the NSA is trying to, in its own words, collect it all. And that knowledge is tremendously important, not just to our society, but to governments around the world as we all collectively try to decide what the right boundaries are on government surveillance.
So a lot of this leads towards the next logical question.
Jump into that, if I might, Richard.
Oh, sure.
Because I'd like to suggest reframing the question in a way. You asked, do we trust the intelligence community to follow the rules? I want to ask the question, what rules? In the sense that, you know, when we think of rules, in one sense, we're thinking, okay, computer flow chart, yes, if this, then that, and so on, and we get down to nice, let's call balls and strikes answers. But the reality is very, very different. The reality is we push and bend the rules to meet the needs that we've got. And indeed, when I look at the intelligence community, I want them to push the rules. I want them to bend the rules. I want them to do everything they can in their legitimate power to keep us secure. But then if I'm going to say that to them, then I've also got to say somewhere else on the chain, there's got to be effective oversight. And I think part of what we're seeing here in the Snowden NSA case is that what we thought, we the people, as oversight has turned out in retrospect to perhaps be much less so when you're looking at a 99%, yes, we'll approve it, yes, we'll approve this, yes, we'll approve this, or in other cases, are they even telling us what's being approved? So I think on the one hand, we've got to really change the question. Not do we trust them to follow the rules, but we got to say to them, you guys, we want you to bend and push the rules as much as you can to keep us secure, but then in a true check and balance way, still secret. I mean, we can't go out, I'm totally with Stewart, we can't tell the enemy what we're doing. I mean, that in some sense, I think is ludicrous on its face. But we, at the same time, as a free people, have got to put into place an effective mechanism so that we can be sure that what these agencies are doing on our behalf to keep us secure are also being done in a way that is truly, and I mean underline that word truly, consistent with American principles of liberty, democracy, and freedom. That's what we don't now appear to have. Go for it.
Yeah, Stan, you were talking about protecting us is really something that no one can argue with. And so the next question gets to the core of that. Can our country be both safe and our citizens' privacy protected? What trade-offs are the American people willing to live with? And are trade-offs, however, actually even necessary?
So what did Franklin say? Benjamin Franklin, you know, if you're willing to trade liberty for security, you will end up with neither of them. And so it can't be a trade-off. It's got to be a yes and, not an either or. And in some ways, part of the reason, you know, I'm going to kind of change hats and put on the ISSA-LA president hat, if you will, for a moment. You know, what I'm really proud about for what we're doing here today is I think this is the most profound discussion a free people can have. How do we balance those two things off? And it's not that you two guys, yep, you're on it right away 100%, or you two. It's this dialogue, this conversation that we're having, out of which we, if we do it right and if we trust each other and continue talking to each other, out of which we'll figure it out. And I think that's part of the perspective that we have to take here.
All right, Stewart, I'm going to ask another question. I think you're going to jump right on this one, so I'm going to tell you ahead of time. It's good. He's number one. Snowden clearly started a debate about the NSA metadata program that will lead to changes in the program, if not its abolition. But since then, there have been hundreds of articles leaking hundreds of programs. Is the damage done by those leaks justified by the debates that they have stirred? And lastly, is it justified by the claims Snowden has made about his motivation in leaking the documents?
No. And it's really a fairly clear story. There was one big debate, there was one big leak, maybe two big leaks right at the beginning about 9 months ago. And that big leak disclosed the 215 metadata program and spurred a big debate. Since then, there have been probably dozens, if not hundreds, of programs and documents leaked that have produced about one more serious debate. There are going to be very few changes in any intelligence programs or oversight programs other than the program that Snowden leaked in the first case. Snowden has continued to leak all these documents and say, well, you know, this is important. I'm starting a debate. And when you ask him, why are you leaking these things? He keeps talking about mass surveillance. I'm against mass surveillance. And that certainly is a good argument against the 215 program. It is not a good argument against most of the programs that are now being disclosed. I have an 18-inch USB cord. You may have seen that Snowden, one of Snowden's leaked documents said this USB cord will broadcast the secrets from your computer if somebody gets close enough to read the broadcast signals. I cannot imagine how you can possibly think that leaking secrets about how to extract information from a USB cord by getting close to it represents anything to do with mass surveillance. Program after program that Snowden has blown has nothing to do with mass surveillance. I cannot see why we continue to tolerate Snowden's claiming to be speaking on behalf of the American people. Most of these leaks are doing great things for Vladimir Putin and nothing good for anybody else.
Nate, do you have anything?
I respectfully disagree. Some of the other programs that we know about thanks to Snowden. So publicly, the NSA has been helping Silicon Valley companies, tech giants like Google and Microsoft and Yahoo, to address the APT, the Advanced Persistent Threat, for years. That's good. That's exactly what they should be doing. It turns out, and we know this thanks to Ed Snowden, that at the same time the NSA was using USB cables such as the one Stewart was talking about, as well as a myriad other techniques to hack those same networks, to tap the fiber lines between Google data centers, between Yahoo data centers, and to exfiltrate information from the same American networks that it was tasked to protect. That's fundamentally inconsistent with its mission. Other things we know about. We know that the NSA in 1976 went and modified the S boxes in DES to make the algorithm stronger. 2004, they did the exact opposite to RSA's BSafe algorithm. We know that the 702 program, which is colloquially known as PRISM, although that word actually means something else, but I'll still use it, the PRISM program was originally designed to fight the war on terror. This is where the FISA court can issue terror warrants, essentially, to get one-end foreign communications. Turns out that some of the biggest customers after CIA and FBI for that data are the Department of Agriculture, the US Trade Representative, the Department of Commerce, the Department of Treasury. These are not terror-fighting departments, and we know that the 702 authorities, the PRISM authorities, are being misused because of Ed Snowden. So it's not just 215, and frankly, it's not just mass spying. It's the abuse of authorities that Congress granted for one particular purpose being repurposed for the Department of Agriculture to do to find out what subsidies are being used across the world. It's not just mass spying that he's exposed. It's the complete failure of oversight. And that's an important story. And that goes even to the sources and methods themselves.
Can I add on to that? I don't know if anyone else is going to jump in. Okay, so I think it's worth also stepping back. I think I agree with Nate that there are a lot more programs than the few that Stewart likes to focus on that Edward Snowden exposed that have been very, very important to the public debate. But stepping back, I think it's worth taking with a grain of salt the claims of harm that are being advanced by many of the same public officials who deceived the public for years about the scope of the NSA's programs. It's not surprising that these claims are being made. Some of the same claims were made about Daniel Ellsberg when he leaked the Pentagon Papers. He was called the most dangerous man in America. That claim turned out to be false. And the very same might be true here. The Director of National Intelligence, when he's behind closed doors, has been a little bit less worried about the leaks that have come out. He suggested that at the end of the day, those who use technology tend to make mistakes. Notwithstanding the leaks, we'll pick up on those mistakes and get the information we want. I think that's likely to be the case going forward. I think it might be that there are a few programs in which the NSA will have to shift its tactics, but it's hard to imagine that the dire predictions being made by some of these officials will bear out. And I think more importantly, though, Nate said it's not just mass surveillance, but I think it is worth focusing on mass surveillance for a second. One of the programs that was also disclosed is a program in which the NSA, for I think 4 or 5 countries, keeps a 30-day log recording of every single phone call made within that country, so that they can at any moment in the next 30 days go back and replay any phone call they want for 30 days. That is the logical endpoint of the arguments that the NSA is making in court and in public about the scope of their authorities. And it's worth us knowing that because that's where things are going unless we effectively regulate the NSA's job, unless we effectively limit their intelligence gathering mission to targeted surveillance rather than the sort of mass surveillance.
So let me ask you, let's suppose that country is North Korea or Iran. Which parts of Iran shouldn't we be looking at? Which parts of North Korea should we not be worried about? Both of them are developing nuclear weapons that they would love to use against us if we could be induced to look away for 3 weeks while they got ready. Which parts of them should we not be gathering intelligence on?
We should absolutely be gathering intelligence
on the North. So that we can figure out if we find somebody and we say, that's the guy, what has he been saying for the last 30 days? Wouldn't you like to be able to do that?
I don't think you need to surveil populations to find bad actors. I think you can target your surveillance at obviously the government.
And suppose you discover a guy as a bad actor on day one and you want to know what he's been up to. Wouldn't you like to be able to look back a ways?
I think the consequence of that argument, Stewart, is a truly scary one. The consequence is that you sanction the creating of permanent databases on whole populations on the theory that you might find something useful in it in the future. And those claims haven't borne fruit. If you look at the 215 program, for example, the phone records program, every body to have analyzed it has suggested that although it has provided limited value in certain circumstances which could have been duplicated by target authority, that program has not ever stopped one of the types of ticking time bomb scenarios you're talking about.
And so we know that it would have stopped 9/11, and the fact that we did not have it meant that NSA listened to a phone call from San Diego to Yemen and didn't know it was coming from San Diego, and couldn't find the people the guys in San Diego were conspiring with inside the United States. Yes, we haven't had that kind of an attack since 9/11, thank God.
Stuart,
but to say, it doesn't work.
What also would have stopped 9/11 is if we had simply run the phone number from that safe house that we knew was making a phone call through a targeted search on companies in the U.S. You didn't need to have 300 million Americans' phone records to find that one call. And that's what the conclusion of the 9/11 Commission report is. I know there's revisionist history going on about how that program would have stopped 9/11.
Well, it would have.
But the fact is that
you're not denying that it would have. You're saying maybe if they'd had all the resources we're devoting now to counterterrorism, and they had decided to go and ask 5, 6, 8, 20 phone companies. By the way, do you have a record of a phone call from this number?
The same phone companies that you go to with the bulk orders.
Yes, but those companies don't save that data, and they don't search it in the same fashion or as quickly.
AT&T saves its data for 25 years. Verizon saves it for 3 years. Sprint saves it for 90 days.
They save billing
Stuart,
information.
you can also
do not save the
save
information.
You can always say, if you scoop up the ocean, you'll catch your fish. Which is why I don't think it's a persuasive argument to say if you just keep a permanent record of what everyone says for all time, it will be effective. If you knock down every door in this country, you would find a lot more crimes than if you did not knock down every door in this country.
This program was not designed to knock down every door in the country. It was carefully designed so that data was collected and then not looked at until there was reasonable, articulable suspicion about a particular number, about which there were maybe 500 numbers. This was a carefully designed program, as carefully as could be designed, consistent with actually having the information when you needed it.
I think the logical endpoint of the arguments that the NSA is making in court, we can have this debate now, but the logical endpoint is a program like the Mystic program, in which every phone call in the country is recorded. And keep in mind, you talk about the restrictions on the 215 program. At the same time, the NSA argues in court that these phone records are not protected by the Constitution at all. And so those restrictions are just a matter of legislative and executive grace. As far as the Constitution is concerned, according to the government can collect those phone calls, they can keep the records, they can keep them for as long as they want, they can look at them for whatever purpose, not just the limited ones you've set out. And these are the legal arguments that you support too, Stewart, that lead to that consequence. So I think it's worth...
I just got to jump in here because, well, a lot of my heart is with the ACLU on this subject, but I'm also old enough to remember when that same kind of domino theory, falling, slippery slope argument was used by the other side to get us into and keep us into Vietnam. And I think it was wrong then, and I'm less impressed by it now, in part for that same reason, not to suggest that we shouldn't be or we should be collecting or not collecting. The question ultimately was harm. And if you just look at, the fact that the fact that our allies now know that we were wiretapping them, separate from whether or not we should have been, but now they know it, that has certainly caused us harm.
They knew that before.
And the fact that we do it to them, they do it to us, we all know that, and we wink. With Snowden, we can no longer wink at it. We now know that it happened. If you're Cisco, this is one of Dick Clark's stories this morning. If you're Cisco, you now have a harder time selling your products overseas because there's the fear that the intelligence community has backdoors in that. So I think the answer, has he harmed us, is yes. I don't think you can disagree with this. But what I think is still, as I listen to the two of you, that, again, it's the beginning of the dialogue, it's not the end of the dialogue. Because it suggests, okay, what are we supposed to do about all this? Where do you draw the lines?
Can I try an experiment to think about this world that supposedly the NSA is bringing us to? If you do business on a network that does not log all of your transactions, would you raise your hand? Yeah, that's it. So we all live in a world where everything we're doing is being collected because it can be, and not by NSA, but for very valid computer security reasons. The ACLU is fighting, the march of technology. Data is going to get cheaper to collect. It's going to get cheaper to analyze. And whether NSA does it or not, it's going to happen because it's happening in this room to the people in this room. Do you feel like you're living in 1984? I don't.
If it were the government collecting, if it were the government sitting on every one of those networks, I think it would be a different question.
Oh, crap. The government can come in and ask for it tomorrow, and they'll get it.
But it's not just the government. I mean, you look at the Internet of Things. Look at the information in the computer boxes in our cars and the question of privacy as to who owns that information. It's in some ways, it's the same question, but realize that it's not just government who may be big brother, it's also Google and all the other companies that are out there that are also collecting all of this information. And unless we have the dialogue around the whole big subject, we're not really having the right dialogue that we need.
I agree with you on that. I think they're two separate questions, though. I think private industry collection of information is a very important question. It's a question that the American public is only now appreciating the importance of, in large part due to the disclosures by Edward Snowden. And I think we should be addressing that. And it's a very complicated question how you think of going forward, protecting privacy in an era in which everyone has an incentive to collect information. But I think that's a different question than the question of whether the government is also entitled to all of the same information. Because at the end of the day, the government can throw you in jail and Google can't. And that's the balance drawn by the Fourth
Google
Amendment.
is not going to stop terrorist attacks, and that's government's job. The government has a more important job to do, and that's why they sometimes need this data, notwithstanding the fact that they have these important powers, the power to throw people in jail because they're terrorists, among other things.
And they also have to abide by the Constitution. And so I don't object to the principle of the NSA collecting this information when necessary. I object to the principle of the NSA collecting it all the time when it's not necessary.
Well, and again, go back in history on this and to support you. I mean, again, I remember when the news was released that the FBI had launched an attack on Martin Luther King. How do we know it? Because people broke into an FBI office in Western Pennsylvania and stole the data. But the King was an enemy perceived of the state in that particular instance. And our government did some really horrendous things in the late 1960s and early 1970s. And as we go forward in this dialogue, we can't forget that. We've got to remember that every bit as much as, yes, by God, I wish we had been collecting that information in September, August of 2001, because maybe we could have stopped 9/11. It's, again, I mean, it's, hold both of those truths in our hands at once and have this dialogue.
Okay, I think we've got some really good. I hope you're all thinking about these. This is great stuff.
Yeah.
We change direction slightly with the next question, touching on some of the legal issues that confront us. Judges are now interpreting the NSA metadata program as either constitutional in accordance with the third-party doctrine or not. It will certainly make its way to the Supreme Court. And what about the third-party doctrine as a whole? Justice Sotomayor has written that it is ill-suited for the digital age, in which people reveal a great deal of information about themselves to third parties in the course of carrying out regular mundane tasks. The Fourth Amendment to the U.S. Constitution protects people's right, quote, to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. How should these two conflicting philosophies be reconciled? Panel?
Who here has any of their data stored in the cloud? Raise your hand. Gmail, whatever. Keep your hands up if you have data in the cloud. Now, put your hands down if you think that you should have any privacy at all in that data. Everyone who dropped their hands thinks that you should have you have no privacy in the data stored in the cloud.
I thought it was the opposite.
I think you might,
okay.
You might ask the right question the other way around.
I flubbed my question. I have a Gmail account. I have some very private information in there. That's the truth, right? And that's the truth for most of us. Most of us keep information in the cloud, and most of us keep private information in the cloud. The consequence of the third-party doctrine, and this is something that comes out of Smith versus Maryland, a Supreme Court case from before the cloud, the consequence of the third-party doctrine is that, taken to a logical extreme, we have no privacy in anything that we don't actually keep locked on paper or on our own hardware in our own homes. And that's simply wrong. And it makes no sense whatsoever to apply the third-party doctrine in the digital age. What does that mean? That means that in order for law enforcement or an intelligence agency to get your data, it just needs to go to a judge and get a warrant, right? The exact same rules that applied in the paper world should apply in the digital world. And I don't think that's a controversial statement at all. The Supreme Court has not touched the third-party doctrine, except in concurrences, since the 70s. It's, as Richard said, it will almost certainly hit the court this year or next. And I think it's imperative, not just for our privacy, but for American business, that the third-party doctrine not extend to information that we keep online in ways that we do have a legitimate expectation that that information remain private. That's just the world we live in today. We need Dropbox and Google to remain private, not just in the way that we think about it, but in a constitutional sense as well.
So Stan started us off quoting Ben Franklin, and I will continue on. Ben Franklin also said, 3 can keep a secret if 2 of them are dead. We all learned in the 3rd grade, more or less, that if we entrust a secret to somebody else, it's their secret to do with what they wish, and it may not be exactly what we had in mind. You want to apply the exact same rules in the digital world that we apply in the physical world? If you take your diary home and leave it with your mom, and the police knock on the door and say, you know, could we have the diary? She can give it to them. They don't need a search warrant to get it from her. They just need to ask. That is the rule we've lived in. Well, why does that make sense and yet at the same time bother us in the digital world? Partly it's because new opportunities to lose our secrets come along all the time, right? You remember, I think your organization was one of the ones that wanted to boycott Gmail because Google was reading it. And we all thought it was kind of creepy, but then, it was a good email service, so we all just got over our creepiness, our feeling of creepiness, and just started using it. Well, that happens all the time. Our judgment about what is a private and what is not changes all the time. The right to privacy that Brandeis told us about, that we all revere him for, you know what he was really bugged by? Kodak cameras. Any idiot could take his picture. He could look bad in it. They could publish it in the paper. He couldn't do anything about it. He owned that. It was creepy that people could be able to do that. He wanted to stop. He got laws passed. Judges adopted this doctrine. And it is stupid. And we are stuck with it today. Even today, if you take a picture of a celebrity, they will sue your butt for hundreds of thousands of dollars because they have a right to privacy, which turns out to be the right to milk their publicity more effectively. And this is the problem of writing this rule, the sense of what's creepy and what's not, into the Constitution by letting 70-year-old judges make that judgment. In fact, your data on Gmail is protected, and it is private, not because it is protected by some constitutional doctrine that will vary based on what people think is creepy today versus tomorrow, but because Congress wrote a statute. We are much better off letting Congress make those judgments than asking the courts what they think is creepy, because, they're kind of old.
Thanks a lot. Go ahead.
Call me old-fashioned, but I think the court should enforce the Constitution. I think the Constitution imposes real limits on government. And I frankly don't trust the political branches to get it right all the time. I think that's why we have courts. We have courts precisely to withdraw from the majority the power to dictate what applies to anyone when it concerns the fundamental rights enshrined in the Bill of Rights. So think about, though, the argument that Stewart is making and the argument that the Department of Justice is making in court when it defends some of these programs. They make the argument that when you share information with anyone else, even through technology, that information becomes free-for-all for the government, subject only to restrictions that a very politicized branch chooses to impose on the government. The problem is that virtually everything we do today leaves some sort of digital trace in the servers of someone else. Almost everyone in this room is probably carrying a very sophisticated surveillance device. They think it enables them to communicate with others. In fact, it enables a host of companies to spy on you through increasingly sophisticated ways. And I don't think I have to tell this crowd how sophisticated those ways are getting. Suffice it to say that one of the latest developments is that your phone can now track your gait, the way that you walk, which turns out to be a biometric that can be used to uniquely identify you. If Stewart is right, if the Department of Justice is correct, then all of that information is fair game for the government under the Fourth Amendment. And I think that would dramatically shift the power in our democracy between the governed and the government. And I don't think that's what the Supreme Court intended when it wrote the very narrow decision it did in 1979. And I think allowing the opinion to be interpret it that way would be a dramatic mistake, and I think it would underserve the tech industry to allow it to be interpreted in that way. I think fortunately, though, the doctrine has never been the kind of on-off switch that the Department of Justice thinks it is, or that Stewart argues it is. I think there's always, the question of sharing information with someone else has always been relevant to whether you have an expectation of privacy, but it's never been the only question. At the end of the day, you also look at the intrusiveness of the government practices, the nature of the information being shared, and individuals' expectations of privacy. And we are now learning what individual expectations of privacy are in the digital world, and I don't think they're what Stewart is suggesting. I don't think people expect that when you use Gmail, that the government all of a sudden gets carte blanche to go through your email. So I think that's, how we draw the line ultimately, I think still becomes a complicated question. The third-party doctrine is not a clean answer, and the proper response will undoubtedly also not be a clean answer. But whatever the right response, certainly the wrong one is that all of this is fair game just because a cloud server is hosting it.
Can I ask a question as the non-attorney on the staff, on this panel, I think? If my information's in Google, let's say, Gmail, whatever, and the government wants it, separate from the FISA court, because that's more bulk collection, doesn't there have to be a warrant issued?
According to the government, no. One circuit court has said yes. The government says no. Congress has a really arcane rule that says if you have opened the email or it is on the server for greater than 180 days, then they don't need a warrant. And that was on the theory that back in the 90s, people primarily checked their email through pop accounts, and so they downloaded their email, and if you left it on the server, you were considered to have abandoned it, which is no longer how people interact with their email servers. So that's a kind of patchwork, but the official position of the United States government is that they don't need a warrant. They will occasionally get one to kind of hedge off these legal challenges.
Something to keep in mind, the official position of Google is that it will not turn over your email unless it gets a warrant. And that, what was that? Google does not turn over email to a law enforcement request without a warrant except in the circumstances prescribed by 2702, which is the emergency exception to ECPA. And you can read all about that in EFF's Who Has Your Back report, which came out just yesterday, which I'm one of the authors of. But so Google demands a warrant before turning over the content of your email, regardless of what ECPA says, because Google is confident that the Fourth Amendment requires it to demand a warrant. It has not gotten pushback from the Justice Department or state and local police or intelligence community since it instituted that policy in 2010. So I think, yes, the Justice Department talks a big game about being able to get your email without a warrant, but Google doesn't turn it over. And I think that's an indication of what the law actually is rather than what the Justice Department says it is.
So I asked my panel to pause because I know you're like racehorses, you're just ready to run, but I want to give the audience here an opportunity. If you have questions, there are mics on either end. Please come and line up. And, but before we do that, and thank you for amazing dialogue, just as I had envisioned it. That's great. Let's try that vote again real quick before you ask. Snowden good, hands up. Snowden bad. I think a 1% change for the good. Okay. So, question, sir?
Yeah, I wanted to make it understood. I still say Snowden bad.
Oh, sorry.
Because my question is going to sound pro-Snowden. I'm not smart enough to understand Section 215 or any of the other issues, but I do have one fundamental question. How can the American people decide whether their governance is acceptable when laws are passed in secret and the court interpretations are also secret?
So the laws are not passed in secret, and the laws are not secret. The interpretations, as Senator Wyden said, are not always in accordance with what people just reading it might have thought. And he objected to that bitterly. And my guess is that in the long run he would have prevailed in any event. The idea that you should say, we want to expose all of the determinations of the FISA court to public scrutiny means that you'll have all the facts of the cases where they're authorizing people to, the government to do collection, which means what? Where do you draw the line? Do you say, well, okay, you don't have to tell us the name of the spy that they're gathering information on. We just want to know sort of a lot about him. But, so does the spy agency that sent him here, and they're going to be reading those very carefully to say, do our spies look like these guys? So eventually you have to say, we're not going to disclose everything the courts have done. And to my mind, we ought to draw that line closer to keeping these things secret than to disclosing them. Because at the end of the day, since we can't make them all public and we can't have a completely public debate, you have to trust the judges to make a decent an honest decision. And there's really no good reason not to trust them, notwithstanding the claims that they're just a rubber stamp. They actually modify about a quarter of the orders that come to them, which is probably 25 times the rate at which criminal orders that come to them for the same kind of review are modified by the judges who review those.
And just to follow on that just briefly, not only do you have to trust the judges if that's the system, you have to trust your elected representatives who sit on the intelligence committees. And if they are not standing in the shoes of the people who elected them and doing what those people want them to do, you need to elect someone else. So I just encourage people to feel like this is not something that you don't have any say in, right? Our system is designed to allow people to vote for the people who are going to act in their stead. Now, everybody has opinions about how well Congress functions, but that's our system, and it's not just trusting the judges who you don't have the opportunity to vote for, but it's your representatives.
On the one hand, though, Monica, and I'm an idealist, I was brought up to believe that. The 60s notwithstanding, my heart is still there. But right now, reality is that 90-some% of incumbents are reelected. They're not facing legitimate opposition. The money to elect them, or the money when opposition comes in, is often coming in not from their constituents, but from out of state, from PACs and other organizations with their own vested interests. That can we really, has America gotten to the stage, to the question, that in fact we cannot trust our democracy? Because I think you can make that argument, and you can make that argument well.
Can I say quickly, I don't think the right answer is either the extremes, expose everything or expose nothing. I think the answer is somewhere in the middle, and it's a hard question to answer. But I think at the very least, the public needs to know the broad ways in which its laws are being interpreted, and that means knowing the legal authority of the NSA, not its targets, not the names of targets, not the specific methods it's using, but the legal authorities. And there is some question at times as to when a legal authority bleeds over into something that sounds more factual and perhaps legitimately secret. And that's when you have the hard debates. And that's, those are hard questions. You could have argued, for example, in the 1970s, when the Foreign Intelligence Surveillance Act was passed, you could have argued that the entire statute should have been kept secret so that the KGB wouldn't know how we went about monitoring phone calls. But I think democracies reject that kind of choice. Democracies insist on a certain amount of transparency so that they can insist on accountability in their elected officials, the way Monica is suggesting, and so that they can either ratify or disapprove of the decisions that courts and their elected officials are making.
Let's get to the next question, sir.
Yeah, it's really a follow-up on what you just said, remembering Vietnam, remembering our invasion of any other number of countries. If we'd had all this technology in place, presumably we could have used it to track down the phone calls that would have disproved that Saddam Hussein was looking for yellow cake and aluminum tubes. But if the rules for gathering intelligence and using intelligence are secret, then the misuse of intelligence is secret, and that has dire consequences in sending us to war and sending people like me who got drafted during the Vietnam War to face death. So you can't have the kind of secrecy that the gentleman has been suggesting. And further, if I heard you correctly, you said something about, well, we shouldn't be listening to certain judges because, they're kind of old. Then why the hell are we listening to you?
So I made that argument precisely from experience. I'm not asking you to let me determine what your privacy rights are, and in ways that you can't later change if you decide, maybe fewer of us should get killed. But I will tell you, and I think you're absolutely dead wrong, and I speak from knowledge here. I was the general counsel of the bipartisan commission that looked into what went wrong with our intelligence on WMD in Iraq, and it was not an abuse by the administration of the intelligence. The intelligence community believed that Saddam Hussein had weapons because he was acting as though he had it. And that was all they knew. Why? Because they had no really good intelligence inside Iraq. Because they were too cautious. They were not aggressive enough. What do you think the effect of Snowden and all of these scandals is going to be? A more aggressive interpretation of the law to find out what kinds of weapons of mass destruction Iran is developing, North Korea is developing? No, we are weakening our intelligence capabilities in ways that will leave us with no good information about some very dangerous countries.
We're running out of time, folks. 3 of you. And the last 2 there, I'm going to buy you drinks after the last session next door. Sorry. Doug, we got time for your question. Real quick.
Okay. I'll try to make this quick. It seems that Mr. Cardozo and Abdo are perhaps a little uncertain about how intelligence gathering might work. And that's more a corollary. My question really is it does seem that there are breakdowns in the way that the protections are supposed to work. One of those breakdowns, and I think there was a mention to that, there was a congressperson who was really upset with the way things were going, and if you read between the lines, I think that was the reference.
It's Senator Wyden from Oregon.
They were upset, but they were prohibited by law from disclosing what was upsetting, and that's sort of bad. And the other thing is, since the courts don't seem to be truly neutral in that sense. And when some of these cases are decided, there was also an editorial in the LA Times that approximated this. What about the idea of having a rotating team of vetted lawyers who will argue for the other side that have been cleared through security? We may not know what's there, but at least but there would be a much more fair process. And when there, as was also disclosed, there were internal leaks or internal violations of policy with the NSA in terms of what they were doing with that there's a really swift punishment, and the people who are affected may not know what happened, but maybe there would be a fine and they would get at least a monetary compensation. That wasn't addressed. And finally, if Snowden was such a good guy, why didn't he do some data masking, and he could have achieved the same effect by releasing 1/10 of what he did and not done nearly as much damage? It was clear he had other motivations in mind, perhaps helping Putin. Thank you.
So I do agree with you about Snowden, and on the question of whether there's going to be an advocate for privacy, there almost certainly will be some change to the law that allows for that. My biggest concern is there are a whole bunch of people in the executive branch now who are devoted from a civil liberties and privacy point of view to getting the government to pull its punches, not to ask for everything, but to ask for something reasonable. And then you're going to appoint somebody whose only job is to say, as unreasonably as possible, no, don't allow that. That's a violation of privacy. I don't think we're setting up a completely fair fight here. We're going to have one guy who is pulling his punches and one who is swinging a roundhouse.
So Stewart's reacting to the current system. The current system is a secret court that meets inside a Faraday cage in the basement of the United States District Court in Washington, D.C., and hears from one side and one side only. We've learned over the course of the last 11 months that the Justice Department routinely misled that court. What is happening now is not working. They're getting one side of the story, and one side of the story from advocates that, in the court's own words, the court can no longer trust. We need something else, and if all we can get is an independent advocate in the FISC to protect, not to push unreasonably, but to push for the Constitution and to push for what the legislators who wrote the laws thought that they meant when they wrote those laws, If that's all we can get, that's worth having.
Okay. Great panel. Thank you all. Thank you all. We're all Americans. Thank you.